Hi, thank you for your post. Basically, your question says everyone always explains information about emotional distress and going to the doctor and showing that you went to a doctor for the distress. But how does one go to the doctor without medical insurance, is what you say. And that's a real catch 22 for you. I have it happen with a lot of people where they would have gotten treatment if they had had the financial resources to do that or the health insurance, being able to pay out of pocket, whatever the case may be. But a lot of people think, well, there ought to be some justice here in this because, hey, I would have gone to the doctor, the therapist, if I've been financially able to. And that's not a question the judge can really deal with. And the reason for this is because we're really not talking so much about justice. That's what everybody wants to talk about. We're talking about the process of the law, the procedure of the law, and how these things roll through. So to prove emotional distress, you have to offer evidence, right? It's a legal claim, so you've got to have evidence of that. The reason that you don't have the evidence is not of no concern really to the judge, unless it was something they could have done, right, during the course of the proceeding. But the judge can't do anything about the fact that you didn't have health insurance or didn't have the money to go there. So when we're looking at proving up emotional distress damages, we have lay witnesses. Lay witnesses would be just you testifying. So you can testify to your emotional distress. You can have friends and family members testify to what they observed about you and your emotional distress. And that's enough by itself for the judge to award emotional distress damages. But if the judge is looking for more, if the judge wants to know more, it's always better to have medical treatment if you've had it. If you haven't, it's understandable, but the judge is only going to be able to go off that lay witness testimony. So if you've been treated by, let's say, your family doctor and been prescribed, medicine because you talked to them a couple of times or they recommended therapy, that's helpful. If you've actually gone to therapy, to a therapist, or going to see a psychiatrist or a psychologist where they've done really in-depth medical examinations and treatment and things like that, that's even better. So we think about this on a range from lay witnesses all the way up through the experts, and you always want to have the experts if you can. But if you don't have those experts, so for example, you don't have the medical information, there's nothing the judge can do about that because the evidence is just not there not because it exists and you haven't gotten it. It's just it never existed because you didn't go. And that's a tough catch-22 to be in. It certainly is unfair in the grand scheme of things, but there's really nothing a judge can do procedurally to cure that defect, unfortunately. So moving forward, certainly can rely on lay witnesses, again, yourself, family, friends who observed you. And that I've won money for folks before with just that type of testimony and nothing else. But we always like to have the medical information when we can. It really supplements, it hits home, it shows what was happening from an objective observer and someone who is experienced and has been treating this stuff for a while. It shows really what was going on with you. So I know that didn't help you per se with this issue, but unfortunately, that's kind of the answer. But I hope the information about lay testimony is helpful.